Please hold on for us. Let me come to the studio to Amanda. You've read the decision of the court?
Yes.
As rendered, the majority and the dissenting, Isifu Umoro, Tanko Amadu. If you have practiced in his court before, particularly when he was in the High Court, he was in the Commercial Court. I don't know how they do the arrangements. His court was always packed. It looks as if they identify those judges who are very efficient, and then they pile them with cases because other courts are often empty. It's like in recent times, if you entered Justice Kweku Akati's court, always packed, and they appear to dispense very fast. But other courts are empty. I don't know how they do it. So reading particularly what he wrote, what Yoni Kolendi also writes, do you agree with them as against the dissent by Henrietta Mensah Bonsu and Ernest Jayo?
Well, I mean, I think they are the seat of authority, and that is why they're sitting in the Supreme Court. So I think I'd make that distinction first and foremost. But the last time I was on this show with you, just a few weeks ago, I said the former Chief Justice would decide this matter. And in a strange way, she has, because she was the only one who abstained from the Council of State decision. And then she made further recommendations as to the constitutional review that needs to be done. And the reason I bring that up to tie into what you've just said is that the suit you just mentioned and practically 4 other suits have been rejected. And the reason they've been rejected is that the process is lawful. That's the irony. The process is lawful, but it doesn't make it just, ultimately. Do we want it to be this easy to remove a CJ? Is the standard high enough? And ultimately, this whole thing got started because who determines stated misbehavior, incompetence, and inability to perform? The person who determines is the executive, in a way, in terms of the petition reaches them and it moves forward. And so that is why we have, as I mentioned when I came on the show last time, the benefit of a former Chief Justice in terms of Akufo, and she's got it just right, in my opinion, because she was very diplomatic in this, in not vocally coming out as much. I mean, I think a lot of the media hasn't picked up on it, but her subtlety perhaps shows why she's a Chief Justice. First of all, she allegedly abstained from the vote as to whether this Chief Justice should be removed. And then within 7 to 10 days, she presents herself before the Constitutional Committee and she says that she really thinks there must be a revision of Article 146 on this basis.
It has to be said for her, though, that she's been working with the IEA since she retired, and together with Professor Michael Quay, the IEA has this committee that's been working for constitution review. And so they have done work for a long time, and this was the product of the work they were presenting to the Constitution Review Commission. Which makes
this even more authentic in terms of her views. Perhaps this is the only person who is non-political in all this, because had she been working on this beforehand, this makes her judgment of this absolutely non-political. And for instance, she says she advocates for the establishment of an independent body to investigate prima facie cases against the Chief Justice, replacing the current 5-member committee appointed by the President. And she cites the Kenyan judicial system as a model, where a judiciary commission comprises of independent experts which handle such investigations without presidential involvement. And as I think he's a professor who just last spoke, he also made a very good point that this whole process has been politicized. And it really is about, everybody's got their political view. Dami's come out and, he's writing it and, making his view and everything. But the truth is she might not survive this process under this constitution. And that is why all 5 cases have failed, because legally it's correct, but do we want to remove a Chief Justice so easily? And until reform comes, every Chief Justice that serves at the mercy of the executive...
You sincerely think...
could be in trouble.
You sincerely think that if the format of determining a prima facie and also setting up the committee to investigate is changed, it will be devoid of the politics, the partisanship we are
it would help.
Treated.
It would help, and that's why she cites the Kenyan...
We will point out which lawyer is in that committee, who is MPP or NDC.
At least they'll be
those who determine the prima facie, the committee that will be set up, whether it's a permanent committee of lawyers or judges, we will look into them and say, this judge is NDC, this judge is MPP. Do you think we will ever have a solution of a reform that will be devoid of the political accusations?
The solution of the reform comes with making it a lot more difficult to get rid of the Chief Justice. Just like with the president, for instance, if impeachment process is ever started against him, it would be impossible, with this current government structure to remove him because of the number of votes. So it shows that, there is a lot of steps that have to take place. So what is being called for, and you're right, justice is not blind, and particularly when we have NPP and NDC. Justice is not blind in this country.
Lady Justice is blind, though. She's blindfolded.
She's not blind.
Yeah.
But, I think what the former Chief Justice is also saying is about this right to appeal. So like you've said, even though, journalists and everybody will comment on how many NPP people, how many NDC people, had the current or the suspended Chief Justice had this right to appeal, this would be yet another hurdle. It's not so easy to just remove her. But ultimately, I think that judicial independence is the soul of the constitutional democracy. And if we lose it quietly, we may never get it back loudly.
Okay.
And I think that is what people are fighting for. Although some would argue, that the former, the suspended Chief Justice should just resign gracefully or exit the stage gracefully. I think she is right to do what she's doing because justice means that we all have to remember she is an arm of government, or was at one point. And just as it isn't, we saw last year, it wasn't easy to challenge the Speaker of Parliament as such. There was huge pushback. There was suggestion about removing, or not removing the president, but possible impeachment actions just last week, vetoed immediately in terms of they couldn't even start the process because it wouldn't go anywhere. That is the argument for the Chief Justice. It must be a lot more difficult. Otherwise, every Chief Justice that comes...
There are those who have argued that this current system is actually very difficult to penetrate. And those who accuse Justice Sophia Akufo, for example, say there was a petition or petitions against her. It's the president who decide whether they forward the petition or not. So you would discover that is why when we're making the OSP Act in 2019, we included that once the president receives the petition, within 7 days, he has to forward it. Prima facie must be determined within this number of days. After that is determined, a committee must be set up within this number of days. The committee has 90 days or so to do their decision and bring. The current constitutional arrangement doesn't have that. So presidents have received petitions and simply trash them. So some people say this particular process, if the president, you are in the good books of the president, you may never get, removed.
And that is why the call for constitutional reform centers around the idea who determines stated misbehavior, incompetence, and inability to perform.
Okay.
And ultimately, there is a call for an independent body to investigate the prima facie case. But I do not believe that this Chief Justice will get the benefit of that. I think that perhaps should a reform come, it will be a lot more difficult. But I mean, the writing is on the wall for this Chief Justice and possibly, the Electoral Commissioner, possibly, just because of the climate of politics at the moment. But this case proves we don't need misconduct to remove the CJ. We only need procedure, basically. And that is really important. And in terms of what the professor was just talking about as well, in terms of in camera, is stated in the Constitution, so that's that.
But
I
so
agree
you're
with
saying
you.
what she's asking she can't get? She
Well,
says
no,
she wants
I
it to
just
be
think
public.
the political... No, but my view sides with you, with what you said. This is public interest like no other. And that, it breeds speculation, having this sort of secrecy element. And also, you can't claim to protect judicial integrity behind closed doors. That's the subtlety of it. The Constitution can say one thing, but public interest always trumps all other cards. And there is no bigger public interest case at the moment than this Chief Justice.
So the question is, can she ask for what she's asking? Will she get it?
Well, the Supreme Court could determine, as they have in many cases beforehand, that public interest is at the heart of this. So they could give her one of her reliefs, which is...
This is the relief we're talking about.
Yeah.
The Article 146, Clause 8 says, all proceedings under this article shall be held in camera.
Yes.
That means in private.
Yeah.
And the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. Mm-hmm. The question is, can the Supreme Court pronounce that this can be otherwise, not in camera?
In my view, yes. I mean, in my view, the Supreme Court has on, I just don't have the cases in front of me, but on countless occasions mentioned public interest as to why they're taking certain acts. And so this is public interest, and if we remove the head of the judiciary in private, we tell citizens that they're unworthy to watch this whole thing.
What's your idea of the purpose of the in-camera hearing?
Well, I think that if justice is truly being done, let it be seen to be done. And, I've noticed since the new government...
What's your idea? What do you think is the purpose for this?
Well, the purpose is transparency.
No, in-camera hearing, when they put it there, that it must be in-camera, why do you think they did it so?
Well, I mean, initially it might have been because to protect the sanctity of the position such that if you were going to remove such a position, it would be dealt with in a sanitized way, and then you present maybe findings in a sanitized way, but it's not the glaring of everything that is out there. I think that was the initial intent of why it was drafted in that way.
My last question about that, do you think this is a right to the Chief Justice for which she can waive, as she purports to say?
It is absolutely a right, and it's not just a right to her, but it's a right to the Ghanaian people. Because ultimately, justice isn't about fairness, it's about visibility. And, with the NDC coming into power of late, I think it's been 3-4 months, which has been, they've had a few Supreme Court cases. Very few have been, publicized. And I don't know if because some of their advocates are a bit nervous about being on camera or whatever, but at this level, as the suspended Chief Justice identified, when she said, if it's public interest, the camera should be in there. We always used to hear Dami's views and, different people's views. And if your argument is that good, let us hear it, because apart from, the justice is sitting there, the public would hear it and the public would know, yes, it does seem to some extent justice is being done. So I do think the NDC's legal team have got to be a bit bolder in terms of not being so fearful of people seeing their advocacy
NDC
work.
legal team?
Well, meaning that when the Attorney General goes, the Deputy Attorney General, etc.
Where?
To the Supreme Court.
No, that's not what we are talking about.
Yeah.
She's saying that the committee hearing for her impeachment should be public.
It should absolutely be
not
public.
the hearing of the case in the Supreme Court. Do you get that?
Yes. But the thing is, public interest
So
invites
NDC
whispers.
lawyers are not involved here.
Okay.
NDC legal team is not involved here. Now, the question is, you say public interest, and that the Supreme Court has many occasions. When you bring a provision for the Supreme Court to interpret, you ask for interpretation because it is what? It is unclear, correct?
Of course.
Okay. So the question many are asking is, what is unclear about this provision for which you can ask the Supreme Court to interpret? Because often when you appear before them, that's the first question. If you can't show why it is not clear, they will throw you out. So what is unclear about it? It says all proceedings under this article shall be held in camera.
Yes, but again, is it just in this case? Because this is very, very high profile. It is to do with the dispensing of someone who sat as a Chief Justice, an arm of government, and one of the highest positions.
Okay.
Do you see what I mean? And I think she's also the third female Chief Justice of Ghana.
Right.
And a lot of questions are being asked as to, did stated misbehavior and incompetence really take place? And if so, you know, let the whole process be in a public forum, ultimately.
In the decision, Yoni Kolendi begins by quoting the oath that the judges take. Part of the oath that they have taken is that they will bear true faith and allegiance to the Republic of Ghana, as by law established, that I will uphold the sovereignty and integrity of the Republic of Ghana, and that I will truly and faithfully perform the functions of my office without fear or favor, affection or goodwill, and that I will at all times uphold, preserve, and protect and defend the Constitution and the laws of the Republic of Ghana. Would you say that the Supreme Court will be defending the Constitution and the laws of Ghana if they interpreted in camera to mean public hearing?
Absolutely. Absolutely.
They'll be defending the Constitution?
Absolutely.
Okay. Now, from the way the cases have gone so far, does it give you any indication that further processes can stop what is going on?
No. That's why I say the writing's on the wall, in my opinion, for the Chief Justice. Because, again, the process is lawful, and that is why the Supreme Court can confidently keep on saying, no, we reject this, we reject this, we reject this.
Okay.
However, ultimately, it doesn't make it just. Do we want it to be so easy to remove a Chief Justice? And do we also want to entertain the idea of an independent body to investigate prima facie cases, therefore a change of the Constitution to make it not only harder, but to have a right of appeal, for Chief Justice to have the right of appeal as well?
Yes.